With the enactment of these three parliamentary legislations, India is set for a significant overhaul of its criminal justice system. The Bharitya Nyay Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Saksha Adhiniyam will, as we all know, replace the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, of course, which was preceded by the CRPC of 1898, and the Indian Evidence Act of 1872. These laws, in a sense, are a watershed moment for our society, because no law affects the day-to-day conduct of our society like the criminal law. Criminal law directs the moral arc of a nation and has the ability of depriving people of their cherished liberties as well. The underlying justification for the substantive provisions is the age-old harm principle, which is best summarized in the saying, "Your right to swing your arm ends just where the other man's nose begins." Procedural law, which governs crimes from the state of setting the criminal process in motion to the conviction for the commission of the offense, ensures that no person is charged and subsequently convicted for offenses without the due process of law. And I think the enactment of these laws by Parliament is a clear indicator that India is changing, India is on the move, and that India needs new legal instruments to deal with current challenges and the challenges which we envisage for the future of our society. Our laws have therefore to aim to give victims a sense of agency and control in the criminal process, as well as a sense of justice. Our laws needed to address these concerns and obviate age-old issues like delays in the examination of witnesses, delays in the conclusion of trials, the overcrowding of prisons, and the issue of under-trial prisoners. The 248th report of the Standing Committee of the Rajya Sabha on the Bharatiya Saksha Samhita of 10th November 2023 noted that the Indian criminal justice system has struggled to keep pace with the profound technological changes, our socio-economic milieu, and that these socio-economic changes have radically reimagined the way in which crimes manifest in society. The growing scope of technology and the new age crime which uses the digital landscape to create networks of collaborative units to commit crimes cannot be pinned to an investigative situs. Today's crime has no investigative situs, no physical situs. This has presented challenges in the investigation of crime, admission of evidence, and prosecution, as well as justice delivery. The newly enacted criminal laws have transitioned India's legal framework on criminal justice into a new age. Much needed improvements have been introduced to protect victim interests and carry out the investigation and prosecution of offenses efficiently. The BNSS encompasses a holistic approach to deal with crimes in the digital age. It prescribes audiovisual recording of search and seizures. For instance, in Section 105, and the presence of a forensic expert at the crime scene for offenses punishable with more than 7 years imprisonment in Section 176(3). The audiovisual recording of search and seizures is an important tool for the prosecution as well as for protecting the civil liberties of citizens. Very often in courts, we hear sordid stories of what happens in the course of a search and seizure operation, particularly under the Income Tax Act. The judicial scrutiny would safeguard the rights of citizens against procedural impropriety during search and seizures. Similarly, the presence of a forensic expert at the scene of the crime, which enhance the efficiency of the investigating team and allow for crimes to be decoded with the aid of the latest advancements in forensic technology. While we make strides in this direction, we must now confront the challenges of fulfilling the aims of the new criminal legislation. Detailed rules need to be formulated on the type of devices to be used for recording, incorporating the principles of natural justice, and lay down the consequences of not carrying out such recordings. We have strategically and persistently worked towards creating technologically equipped court systems which can facilitate a citizen-centric and efficient mechanism from the filing of a case to its disposal. Recently, the Government of India has sanctioned a budget of 7,000 crores for the Indian judiciary as part of the e-courts project. It was therefore very heartening to notice that Section 532 of the BNSS allows for all trials, inquiries, and proceedings under the code to be conducted electronically in Section 532. As laudable as this addition is, we must continuously introspect and protect the privacy of the accused as well as the victim when dealing with digitization of proceedings and creating digital evidence. In the digital age, the data and sensitive information of a person has gained paramount importance. This data can allow us to gain unparalleled efficiency and ease. However, the power which comes with personal data puts a corresponding duty to make systems which are immune to penetration and leakage of data. In particular, clauses 3 and 4 of Section 532 of BNSS allow for the examination of witnesses and evidence through the electronic mode. The access ushered in by this provision will impact the access of witnesses to the courts and reduce delays in trials on account of the absence of witnesses. Key provisions of the new criminal law would only produce a positive impact if these investments are made as soon as possible.